Yesterday I got a call from senior lawyer, former cop Michael Woods, and he said to me, there is something going on, Leon, with regards to bail that I think your listeners need to know. And this is the basic scenario. When anyone is arrested for any purpose or reason, one of the new conditions, it's a precondition if you like, to get bail, is that if you are a registered legal owner of a firearm, you must surrender that firearm. And furthermore, the onus is placed upon you that at any time, in a random sense, you can be tested for any traces of the use of a firearm. Now, some people might say, well, that seems like a fair thing. You know, we've had a lot of gun violence in the city, drive-by shootings, all that sort of thing. So maybe this is warranted. Now, as we always do, we give you both sides of the story, but let's let the man who brought this to my attention explain. Senior lawyer from Woods & Co, Michael Woods. Michael, what's your concern about this, and good morning?
Yes, good morning, Leon. Good morning, listeners. I have a number of concerns about it, and I think I know you're going to have John Rowe on in a minute, and maybe he might be able to respond to some of these concerns. But the fundamental issue is this. I don't think you would get argument from many people in society that want to protect serious firearm-related violence, whether it's drive-by shootings, the efforts that the police do and the efforts that the government do are quite important. But like so many of these pieces of legislation, it seems that in legislating, ordinary members of the public get caught up with these pieces of legislation in ways that were possibly unintended. Now, that's something you might be able to ask the Attorney General as to whether this is an unintended consequence, and if it is, well, he could perhaps look to amend it. If it's not, then let's find out why. Is there some underlying scheme to simply remove firearms from the public eye in any way, shape or form? My concerns are this. The amendment came in with what they called the Statutes Amendment, in brackets, Serious Firearm Offences Bill. Now, in general terms, the Serious Firearm Offences Bill deals with serious firearm offences. That sounds quite logical. And those are use of Class H guns belonging to motorcycle gangs and serious firearms offences. No doubt about that. That along with that, if a person is charged with a serious offence of that kind or one of violence, then one can understand wanting bail conditions not to have a firearm in their possession. The unintended consequence of this, though, is that the Act has been worded that every grant of bail is subject to a condition prohibiting an applicant from possessing a firearm, and every grant of bail is subject to a condition requiring the applicant to submit to tests, including testing without notice for gunshot residue, as may be reasonably required by the bail authority. Now, in practice, the magistrates are just basically regurgitating those words as required by, the bail authority. Now, this leaves open all sorts of scenarios. For a start, an average person, no prior convictions, who's a gun owner, and rightfully so, a gun owner who shoots, who recreational shoots, you can have someone arrested, quite commonly for not serious matters when there is no threat. Now, matters such as disorderly behaviour at the cricket when you've drank too much and you end up getting locked up in a bail agreement. Some driving offences, driving in a manner dangerous, can end up with being arrested. In fact, you could actually be arrested for any offence, but leaving that aside, and the police are supposed to report you, and whether they're on the increase of arrests, I don't know. Sometimes I wonder, because of the collection of DNA evidence, which is more the topic of where we were yesterday, there seems to be a lot of people arrested. But leaving that anecdotal it aside, I do note under the Act that there are only very limited conditions where a court can remove those conditions. And a bail authority has to be satisfied by evidence on oath, for a start, that there are cogent reasons to remove any condition of it. Now, really, again, that's the reversal. I don't mind, again, with people on parole, sentencing, ones who receive suspended sentence. They are convicted criminals in that way. But a person on bail, A, has a presumption of innocence. and B, there should be a presumption of bail. These sort of things where, again, you have to prove that you have a cogent reason, and that means a convincing or powerful reason to keep your firearms whilst on bail, and you have to give evidence on oath before you can do that, seems to put the reversed onus. And worse than that, if a person doesn't, let's assume a person doesn't even have a firearm and they get locked up for disorderly behaviour or a urinate in a public place or offensive language, they're not really a violent offender. The police can simply put that condition on them without needing to bother about it, and without removing the condition. And not only that, they can knock on their door at 2 a.m. in the morning to test them for gunshot residue. Now, that sort of abuse is very, very real and very, very open. And believe you me, it will happen. There will be people that rub them up the wrong way, the same as they check at 2 in the morning for curfews on bail. The same other reasons they'll be doing it to knock on someone's door at 2 in the morning to do a gunshot residue when the person wasn't even charged with a firearms-related offence. Now, I find that concerning. I find that, once again, another erosion of people's rights. And I have no hesitation in saying that if the government want to do it for convicted criminals, or they want to do it for people charged with serious offences, serious drug offences, matters in the district court, or matters of significant violence, then that's one thing. But to apply that to every grant of bail again is another erosion of people's rights, and something that I personally don't support.
All right, stay on the line, Michael Woods. John Rao, Attorney General, thanks for coming on. You've heard what Michael said. How do you answer what he suggests?
Well, look, just to clarify a few things, look, I understand Michael's point of view. I think, look, for a starting point, we have a difference in policy here. My concern in putting this legislation together, and the government's concern, is to make a very clear statement to the community that as a group we are sick and tired of firearms offences, and we will tolerate no abuse of firearms at all. That's point number one. Point number two is, in respect of bail, the provisions that we're talking about here do not reverse the presumption in favour of bail for anybody except serious offenders like people who've been out there shooting at people or serious crime offenders and so forth. The ordinary person still has the presumption of bail. Very important point. Next point is that we say that the default position in any bail application, now remember, a person has to be arrested before they ask for bail.
Yep.
So you don't normally arrest people for dropping a newspaper in the street or something of that nature.
No, but you can, and people are arrested for disorderly behaviour, for example.
Sure.
Yeah.
They are. But in the event of them being arrested, then a standard condition of bail is that you do not possess a firearm, okay, or you not have in your possession firearms or ammunition. Now, if you have a good reason, for instance, you're a farmer or something, or you're a person who's a regular sporting shooter or whatever the case might be, for asking for that to be varied, you can, and it can be varied by the bail authority. And again, I think, with respect, Michael wasn't quite right about this. He said you had to give evidence on oath. That is only if the bail authority is a court. If the bail authority is simply the police officer, because you're getting police bail, you don't have to give evidence on oath. You simply just have to explain to the policeman why it is that you need to have possession of firearms. So all we're doing is saying the onus on anybody who is arrested for something is that they need to explain to the policeman or the court that is hearing their bail application why it is they need to have a firearm.
All right, stay on the line. We'll get back to Michael Woods in a sec to clarify. First, Kat's got a question for you, John. Kat, what's your question?
Hi. Look, this really concerns me because it's sort of like we're heading into Nazi Germany territory here. Okay, I own 12 firearms. I like firearms. My family likes firearms. We like going hunting and shooting and camping and that sort of thing. Now, if, say, I was arrested and, which I can't see why, but anyway, say I was arrested for something that I didn't do, and down the track it was proven that I didn't do it, and that I was falsely arrested, why on earth should I give up my firearms when I didn't do anything wrong? And also, why on earth would I want to give up my firearms if say I was arrested correctly and it had nothing to do with a violent crime or a firearms crime? you know, if I was just, say, speeding ridiculously and I was arrested, what on earth has that got to do with my firearm?
Okay, John Rao?
Well, look, I understand the point, but I'm not sure Kat was listening to what I said before. If you are a person who is arrested for something which has got nothing to do with violence or nothing to do with abuse of firearms, all you need to do is to say to the bail authority, look, this is not a violent offence. I'm not a violent person. I've got no violent record. I'm not charged with a violent offence. I have registered firearms which I have never abused the privilege of having. I would like that condition of bail to be dropped or varied, and that is up to them to do it. The point is, though, Leon, there are a lot of people who might be arrested for example, dangerous driving,
Yep.
who, as it turns out, are not doing the right thing with firearms, who might possess a firearm which is an unregistered weapon, or they may have...
well, hang on. If they've got an unregistered firearm, that's an offence in itself, and that's already dealt with in law, isn't it?
Sure it is. But I'm just saying, these people who are legitimately and lawfully possessing firearms and who have not been charged with a violent offence, all they have to do is say to the court or to the police officer who's the bail authority, look, I'm not charged with a violent offence. Here's my gun licence. I have registered firearms. I've never been in trouble with the police about these things. Can I please have an exemption from that thing? It's as simple as that.
All right, Michael, what do you say to this?
Well, look, I don't think it is as simple as that. I think the attorney is underplaying the legislation and the practical implications of it, with all due respect to the attorney. And John knows I've got a lot of time for him. But I don't think he's giving that the effect. The true policy is, as he said, to get firearms off. It's even in the Hansard that I read last night, where they even were focusing back on the Port Arthur and the national attempt to deal with firearms. And I know that was the member for Bragg. But the general topic of conversation was that. Secondly, I do take issue. The attorney is right in one respect, that if a bail authority is a court, it's only allowed to be satisfied by those matters by evidence given on oath. Now, one, I would ask, why is a court in a more restricted position than a police officer? Again, that seems to be wrong to me, to be giving greater and wider powers to the police, who are bail authorities, than it does to a court, who is only able to be satisfied by evidence given on oath, a judicial independent officer, not the judge, jury and executioner, as they say. I find that an odd piece of legislation, and I can tell you in practice that nearly every bail authority, when they get there and there happen to be a police officer, they will be making those stock standard conditions and saying, well, if you want it removed, you go to a court, which is exactly why I said that it's evidence on oath, because that will be the practical application of it.
And another senior lawyer, who shall remain nameless, has said that bail authorities will not amend their conditions. It becomes an expensive exercise to remove conditions.
Well, I can say this as well. The Crown have taken the view that any existing bail authority, as it is, as soon as it is amended, it becomes a new bail grant. So we're already now having people that simply want to change address on an existing bail agreement, who are now have to be subject to this firearms condition, who might well have been on bail for the last 6 or 8 months with their firearms, committed no offences whatsoever. They change their address or they change an aspect of their bail to go into state, and the courts are demanding that every new grant of bail be subject to these conditions. So it's been all right for the last 8 months for them with the firearms to be in their possession, and now, of course, with the new legislation, oh no, it's not. Now, the other bit is this term cogent reasons. I will guarantee you it's not a matter of simply asking the bail authority to remove it. It will not happen that easily. The cogent reasons are described as being compelling, convincing and powerful. I will guarantee you this, and the attorney can check with us if he wants to see the stats later and see what the Supreme Court say about it. They will certainly consider that it will need to be compelling, convincing and powerful, and not your average bloke who says, look, I've been a member of a shooting club for a lot of years and I'd like to continue shooting and I've done nothing wrong. Watch this space is all I'll say. And it is a concern, and I'm not saying I support firearms or firearms violence. I think you know me well enough to know, and the attorney knows me well enough to know, look, there is a time and place. I think they should have restricted it to serious offences. I think they should have. That was the intent of the legislation. I actually tend to think this is a bit of a byproduct where people got caught up with it. That's what I was hoping the attorney was going to say, and there should be more discretion with a court. It shouldn't be mandatory, which again takes the powers away from the court. The whole time, every piece of legislation lately, even on this serious firearms offences, is directed at taking powers away from the court. Instead of having that separation and independent judiciary, we're left with Parliament prescribing, even on these serious firearm offences, that a court cannot give a suspended sentence effectively for a serious firearms offence. Now, that can lead to inequity. Now, I know that the attorney will say, oh, yes, there are some exemptions under that as well, and yes, true, that is. But the reality is, by legislating with mandatory sentencing at all the times and by legislating these sort of things, they take the power away from the judiciary and they effectively put it in the hands of the legislator enforced by the police. And there's been so much legislation recently that has that flavour about it, and that concerns me.
Michael Woods, thank you. You've explained your position well. So, John Rao, is there any ground that you would give to anything that Michael Woods has said today, or do you think it's wrong?
Look, Michael's a very very well-respected lawyer, and he does a lot of good work in the community, usually defending people who are charged with various offences, and I respect his opinion. But the fact of the matter is that as a policy decision, we've decided that we want to make it crystal clear that firearms misbehaviour is totally unacceptable. It may well be that if it turns out that the law is as Michael says, and it causes hardship, we can have a look at that at some stage in the future. But I do want to make it very clear, there is nothing in here about mandatory sentencing. That is completely not the case. In all instances, the court has a discretion to be able to not impose any particular penalty on even firearms offenders. They've still got a discretion. But what we have said is the public have told us that they do not want the courts releasing firearms offenders unless it's an exceptional reason to do so. That's what the public keep telling us, and that's what we have told the courts the public want. That's all.
All right. John Rao and Michael Woods, thank you.